Good afternoon to you. Today we will continue with the Constitution. This is Judiciary Part 3. Judiciary Part 3. In the last class, we have seen the constitutional provisions regarding appointment of judges, the collegium system, and the attempt of the government to establish National Judicial Appointments Commission, and how the 99th Constitutional Amendment Act was declared null and void. Today we will continue with the other provisions of the Constitution regarding Union Judiciary. Once appointed, the Chief Justice of India and other judges of the Supreme Court, Chief Justice of India and other judges of the Supreme Court should be administered oath of office by President or by his nominee in the format given in third schedule. Understand? Third schedule. Where is the oath given? Third schedule. Who administers oath of office? President or his nominee. Not necessarily the president. President or his nominee. What is the format? Format given in third schedule. Another important thing is the oath is same for the Judge of Supreme Court and CAG. Judge of Supreme Court and CAG, the oath is same. This you should know, very important. Secondly, a judge of the Supreme Court can resign by writing to President. Whether the resignation tendered by a judge can be withdrawn, this question came up before the Supreme Court in G.C. Mishra versus Union of India case of 1978. In this case, the Supreme Court held that in the absence of any contractual or constitutional basis, a prospective resignation can be withdrawn before it becomes effective. But if he chose to resign immediately, then it cannot be withdrawn, because a judge is not supposed to relinquish or assume charge. On his own volition he goes, and on his own volition he can come back. So if the resignation is prospective, he is free to withdraw. If the resignation is to be effective immediately, then he cannot be withdrawn. This is the decision of the Supreme Court in G.C. Mishra case. Next, a judge of the Supreme Court has a term up to 65 years. What is the age limit? 65 years of age. Please note that the tenure of the Supreme Court judge in USA is for life. Secondly, the age of the judges of Supreme Court shall be determined by such authority and in such manner as the Parliament may by law provide. Who decides the age? The Parliament may by law. What is the age limit? 65 years, the maximum. In USA, it is life. Don't you think that the USA type is better, so that it will infuse a more independence of judiciary? This is the question you should think over. Secondly, when the office of Chief Justice of India is vacant, or when he is unable to perform the duties of Chief Justice of India, his duties will be performed by such one of the judges as the President may appoint. Here, note, no seniority is mentioned here. No senior most judge will become the Chief Justice of India as acting Chief Justice. No. Any judge whom the President nominate. Most important point. These are all small points where a person can be made to be trapped in the prelim. Next. Now we will come to the appointment of ad hoc judges. What is ad hoc? For a special purpose. Judges who are appointed in the Supreme Court, when the ad hoc judges are appointed in the Supreme Court, when there is no quorum. When there is no quorum. What is quorum? We will see later. Two groups of dignitaries can be appointed as ad hoc judges. Number one, High Court judges. Number two, retired judges. Now, if there is no quorum of Supreme Court judges to hold any session, the Chief Justice of India with the prior consent of President. Three people are involved. Kindly note. If there is no quorum in the Supreme Court, then the Chief Justice of India, with the prior consent of the President and in consultation with the Chief Justice of the concerned High Court, three people, the President, Chief Justice of India and the Chief Justice of the concerned High Court in consultation, can request in writing the judge of that High Court who is qualified to be appointed as the judge of the Supreme Court. Another qualification. Who is competent, who is qualified to be appointed as the judge of the Supreme Court to function as the judge of the Supreme Court. Please note that there is no need for any consent of the judge who is proposed, because this becomes his duty. A person already working in the High Court as judge, and what is the eligibility? 5 years. So if he has completed 5 years, he becomes qualified to be appointed as judge of Supreme Court. So the Chief Justice of India, with the approval of the President of India and in consultation with the concerned High Court Chief Justice, can request that judge of High Court who is qualified to be appointed as the judge of Supreme Court to function as the Supreme Court judge. And he has to obey. In this case, the judges will have all jurisdiction, powers and privileges and shall discharge the duties of a judge of Supreme Court. This is one. Secondly, retired judges. In this case, retired judges of Supreme Court and High Court may be requested. Remember, retired judges of Supreme Court and High Court may be requested by Chief Justice of India with the prior consent of the President to function as the judge of Supreme Court, provided the retired judges are willing. Number one, because there is no obligation for them to agree to the request of Chief Justice of India. Here, these ad hoc judges are entitled to such allowances as the President may determine and will have all jurisdiction, powers and privileges of the judge of Supreme Court. However, he shall not be deemed to be a judge of Supreme Court. He cannot be completely equal to the judge of Supreme Court. Here another point you should remember is, when you are asking a retired judge of High Court, you should choose such person who was qualified to be appointed as a judge of Supreme Court. Or you can choose both retired judges of Supreme Court and retired judges of High Court. Retired judges of Supreme Court, there is no problem, because already Supreme Court judge. If you are choosing retired judges of High Court, then ensure that the person whom you choose should be qualified to be appointed as the judge of Supreme Court. Second point you should remember is, he should be willing to work, because you cannot compel a retired person to work, to come and work. So the obligation is that he should be willing to work. And the third point you should remember is, he shall not be deemed to be a judge of the Supreme Court. No doubt, he enjoys all powers, immunities, privileges, but you cannot say that he is a full-fledged Supreme Court judge. That point you should remember. Secondly, now let us come. What do you mean by quorum? I said when there is no quorum in the Supreme Court, very easy to say. What is quorum? Quorum is the minimum number of judges required to make a transaction valid. That is the normal. But here there is no question of anywhere. But it is indirectly implied. That means, bail application in appeals are heard by single judge. In the Supreme Court, if there is a bail application in appeal, High Court decides and appeal, it is coming on appeal, the bail applications in appeal are decided by a single judge. This is called chamber judge. Secondly, most of the matters are decided by the division bench, that is the judges of the Supreme Court. If two judges, that is the division bench consists of two judges. If the two judges disagree, which is very rare, the view of the senior judge will prevail. So, division bench consists of two judges. and most of the matters are coming to the division bench. It consists of two judges, and if there is a difference of opinion among the two, between the two, then the senior judge opinion will prevail. Number one. Secondly, priority matters, very important, priority matters are placed before three judge bench. Three judge bench. Fourthly, all cases involving constitutional matters and President's references under Article 143 are referred to five judge bench, which is known as Constitution bench. So, five judges minimum should be there. If it has become less than five, then it means there is no quorum. Such an occasion in Supreme Court is very rare. But of course, High Court it happens. In fact, latest there is in Northeast High Court there was no quorum. That was the issue. But Supreme Court such occasion is very less. Now 34 judges are there. Naturally, 5 judges easy. So the such occasion, lack of quorum will be very rare in Supreme Court. The largest bench so far, as I already told you repeatedly, 13 judges bench, which delivered the judgment on Kesavananda Bharati case on 24th April 1973. Another landmark judgment of Golaknath case of 1967 was delivered by 11 judge bench of Supreme Court. Now let us examine the removal of judges of Supreme Court. The same procedure applies to removal of High Court judges also. Why? Because we have unified judiciary. We have unified judiciary. The appointment and removal are all done by the President of India only. A judge of the Supreme Court can be removed from office by an order of President. By an order of President. It is an executive order. Okay. Passed after an address by each House of Parliament, supported by a resolution, passed by a resolution by special majority on the ground of proved misbehavior or incapacity. So, proved misbehavior, incapacity, resolution passed by special majority initiated in either House of Parliament. The Constitution lays down that the Parliament may by law regulate the procedure for presentation of address and for investigation and proof of misbehavior or incapacity. Accordingly, Judges Enquiry Act 1968, underline, Judges Enquiry Act 1968 has been made. The Act provides certain procedure. What is the procedure? Under this Act, a removal motion may originate in either House of Parliament. First point, a motion can be initiated in either House of Parliament. To initiate the proceedings, at least 100 members of Lok Sabha can give a signed notice to the Speaker Lok Sabha, or 50 members of Rajya Sabha can give a signed notice to the Chairman Rajya Sabha. The Chairman or the Speaker, as the case may be, may consult the individuals or experts or examine relevant materials related to the issue. After having been satisfied of the relevance, the Speaker or the Chairman will admit the motion. If the motion is admitted, the Chairman or the Speaker, as the case may be, where it was originally given, will constitute a 3-member committee comprising a Supreme Court judge as the Chairman, 1 Chief Justice of any High Court as the member, and a distinguished jurist again as a member. The committee will frame the charges based on which the investigation will be held. During the inquiry, the charged judge will have the right to defend or be defended, because the basic jurisprudence principle is no person can be condemned without hearing. Then, after the inquiry, the committee will submit the report to the Speaker or Chairman. If the committee finds him guilty, suppose if the committee says there is no substance, no further. Remember, no further. If the committee found him guilty, the findings will be placed before the House, and the House will take up the motion for discussion and removal. And if the House, if where it is given, that House has passed the resolution saying that the charges included the resolution has been sustained, then it has to be passed by special majority, that is absolute majority plus 2/3 majority of the members of the present and voting. Then after having been passed by one house, it is transmitted to the other house. Other house also will discuss. There is no need that other house will agree whatever the law first house has told. It is not mandatory. So the second house will discuss, again examine the charges, and after a detailed discussion in the house, if the house passes the resolution that the charges framed have been sustained and the resolution having been passed by special majority in that house, then both the resolution will be sent to the President of India for issuing the order, who will, after seeing the resolution, President of India will issue the order. This is the procedure. The judge of the Supreme Court is removed under Article 142 and the judge of the High Court is removed under Article 217. But the procedures are same. Procedure is same. Then, so far, no judge of the Supreme Court or High Court has been removed from office, even though a few motions were initiated, in some cases unsuccessfully voted and disposed of. These cases are: number 1, Justice V. Ramaswamy, Chief Justice of Punjab and Haryana High Court in 1993, Justice J. B. Pardiwala, Judge of Gujarat High Court in 2015, Justice P. D. Dinagaran, Chief Justice of Sikkim High Court in 2011, Justice Soumitra Sen, Judge of Calcutta High Court in 2011, Justice C. V. Nagarjuna Reddy, Judge of High Court of Andhra Pradesh in 2017, and Justice Deepak Mishra, Chief Justice of India in 2018. This is the procedure. We will continue in the next class. Thank you. Thank you.